Yeah, welcome back to the Legal Clinic. And we have with us lawyer Mohammed, who has been with us since day one. Today we'll be discussing customary law and statutory law. Are they at conflict or they can actually coexist? Counsel, you're welcome to the Legal Clinic.
Thank you.
It's good to have you once again.
I'm also grateful to be with you.
God bless you. So let's just proceed with our discussion.
Okay.
When we talk about customary law, what exactly do we mean?
Okay. Customary law, Article 11 of the Constitution has told us that customary law is part of the laws of Ghana. And it is the laws of the people's customs and traditions by which they rule. They are at the local level. That is what actually forms the customary law. That is the traditions and the norms with which the people used to rule at the local level, to rule on matters of their marriages, rule on matters of land acquisition, rule on matters regarding paternity of children, and a lot more. That forms the customary law. And it is what they've used for years. Then became part and parcel of them. That's the customary law in brief.
Okay, thank you, Counsel. When you say they have been ruled with the customary law for years, do conflicts arise when it comes to the statutes and then customary law in Ghana?
Fine. Before we had the laws postulated in the statutes, we had the local adjudication. Okay. That is traditional means of resolving matters. And because it was there before the law of the statute came, there was a need for a point of coexistence such that there's no conflict. Because if there's conflict, then the system will create chaos. So currently, customary law and the law by the statute, they coexist. They need not conflict. That is why the Constitution, Article 1.2, told us that any law, any act, any provision that contradicts the Constitution, which is a statute, Constitution is to the extent of that inconsistency null and void. So if customary law is used in resolving a dispute, and part of the customary law does not give credence to the statute law, then that part is null and void. But the part that gives credence to, that part is not null and void. So they should coexist. And they are coexisting as at now.
Okay, yeah. Thank you, Counsel.
You're welcome.
So my next question is, in case a conflict arises between two individuals, let's say A and B, which law will be used to settle the matter? Or does it depend?
Okay. You know, when two people go into agreement, there's something we may call arbitration clause in the agreement. Yeah. The arbitration clause tells us that when there's conflict between us, this kind of law is what we should use to resolve it. But mostly, they don't use customary law. They will use the law by the statute. Okay. You understand? So it is when the matter goes to the law by the statute, which is the court, that the court by section 7 or 64 or the provisions I mentioned earlier may say, okay, this matter can be resolved under customary or at the local level or through arbitration or mediation. So let's refer it to the place. Then afterwards, we are noted. So when there's dispute, it depends on what the law the agreement talks about. Okay. If there's no law, then the first forum should be the court. Okay. The court, before the court finds that this can be resolved at customary level or arbitration or mediation, then the court will refer it.
Okay. Fine. So with this, I can tell that there are elements of legal pluralism in our system. What are some of the benefits that we can derive from this kind of system?
Okay. Yes. You see, legal pluralism is simply talking about having a number of legal systems, but coexisting. Okay, that coexist at a point in time. And the benefit is that, for example, the arbitration mediation forums, the benefit of it is it decongest the court.
Okay.
Okay, it helps to expedite resolution of certain matters. A matter that may spend about 10 years in the court because of the number of cases in the court and then the formality of court processes. When that matter is given to another forum like the mediation, arbitration, or customary level of resolution, you see that the number of years the case will spend in the court will be what? Will be cut short. So there are actually benefits of having these systems in place to decongest the court, to expedite, what do you call it, the resolution of the matter, and then to ensure that after the resolution of the matter, the people are not at loggerheads, but at what? At our friends. You know, when we do litigation, it's a win-lose affair.
Right.
So after that, there is rancor between the parties. I've won, you have lost. So you see that we have problem. But when the matter is resolved in forums that support the court system, you see that it's not a win-lose.
No,
it's a win-win.
Win-win affair.
You win some, I win some. So when we finish, we even shake hands before we move on. So there are benefits in having these systems, but they must coexist.
Okay, so counsel, has there been an instance where, let's say, the customary law conflicts with the statutory law of Ghana, and when that happens, how do we go about it? And who is even supposed to initiate that action?
Okay, there are a number of situations where customary law conflicted with the law of the statute, and when that happens, the law of the statute takes precedence over the customary law.
Why?
Fine, because you see, customary law, the formalities for doing things, the procedure can be compromised by the people that are in charge of it. You see, I'm not saying the chiefs and the people have problem, but there are certain cases that have come before the chiefs, some chiefs, and the way they approach resolving the matter, the parties find it to be a problem. For example, if the matter goes to a chief palace between, let's say, an Ewe and an Achim, and then the matter is in an Achim chieftaincy area, certain utterances like "you cry, you are a stranger in the Achim land." How you see this thing will not happen in the court.
No.
The moment you mention this at the grounds, the party who is not an Achim, an Ewe, will see that no, these people will not be fair to me.
Right.
The same way, if it happened in the Ewe land, and then an Achim person or a Northerner is told, you cry, you are a Northerner, you are an Achim person. How did you get this vast land in the Ewe land? He or she too will think that no, the people will not be fair. By the court, there's nothing like you are a stranger, you are whoever. It is right to sell or right to grant. That is what is important. Whether Ewe, Achim, or whoever, once the land is determined to be yours and you can grant it, the court will allow you to grant it to whoever qualifies to take the grant. So when there's conflict between customary and then statutory law, the law by the statute must prevail, and is justified that it must prevail. For example, under the customary law of marriages,
Okay.
when you marry someone, the customary law, you may register it or not.
Right.
Then, if you don't register it, it doesn't mean the law is not valid. The marriage is not valid, it's valid. Because the registration is optional. But when you are dissolving that marriage, you are expected to do it customarily. But where there are properties involved, what you call ancillary matters, compensation and all those things, the best way to resolve is to use the court. Under section 41 of the MCA, Matrimonial Causes Act. You understand? So when you do that, you are able to what? To get the matter resolved properly, rather than go the customary way. That is why I'm saying that when there's conflict between customary law and statutory law, the statute must prevail. And the statute prevails to ensure that justice is what meted out to one who justice deserves to be given that outcome.
Counsel, thank you so much.
You're welcome.
I think what I've learned so far is whenever customary law and the statutory law, whenever there's a disagreement, the statutory law must prevail. Thank you so much for
You're
joining
welcome.
us.
You're welcome.
So we'll take a quick break and then proceed with the next part.
You're welcome.